Good day everyone, I am Clarissa May O. Pipito and today I'll be discussing one of the most important environmental legal remedies in the Philippines, the Writ of Kalikasan. Under the Rules of Procedure for Environmental Cases or AM number 0968-SC. This rule took effect on April 29, 2010 and it introduced several legal tools to address urgent environmental problems in our country. One of those remedies is the Writ of Kalikasan, which protects our constitutional right to a balanced and healthful ecology as stated in Article 2, Section 16 of the 1987 Constitution. So in simple terms, this writ helps protect nature when it is being threatened or destroyed on a large scale. So maugi ni siya ang purpose, to safeguard the environment for everyone. So, next slide. Let us start by understanding the foundation and purpose of this writ. So, the Constitution itself provides the foundation for the writ of Kalikasan. Article 2, Section 16 of the 1987 Constitution states, "The state shall protect and advance the right of the people to a balanced and healthful ecology in accord with the rhythm and harmony of nature." So this means that protecting the environment is not just a choice, but a duty of the state. The Supreme Court then created the Writ of Kalikasan as a legal remedy to make this right enforceable in court. So kung naay threat to the environment, dili lang ta magpaabot, we can act through this writ. And let us move on to its main objective. The Writ of Kalikasan serves as a quick and effective legal remedy when the environment is threatened by the act or omission of a public official or a private person or company. But take note, it only applies to the environmental damage of such magnitude that it transcends the personal or property rights of individuals. Meaning, it's not for small, isolated problems. It is for large-scale damage that affects an entire community or region. For example, if a mining company causes massive soil erosion or pollution that affects several towns, that can be a ground for a writ of kalikasan. Ang main goal ani is to stop or prevent that damage before it becomes irreversible. So, third is legal basis. So, where this writ is legally based. So, the writ of Kalikasan is found under AM number 09-6-8-SC or the Rules of Procedure for Environmental Cases. Specifically, it's in Part 3 Special Civil Actions Rule 7. And this rule clearly lays down how the writ works, who may file it, where to file it, and what requirements must be met. So the main goal of the rule is to ensure speedy and effective resolution of environmental cases, since time is crucial when it comes to nature. And as we know, once the environment is destroyed, it's hard to bring it back. That is why the Supreme Court made this process fast and accessible. Now that we've talked about the background and purpose of the Writ of Kalikasan, let us move on to the next part, its coverage and nature of remedy. So this will help us understand who can file it, what kind of damage it covers, and how it differs from other legal remedies. So, definition, a writ of kalikasan is a special legal remedy that can be filed by different types of persons or groups, not just individuals. It may be availed by a natural person, a juridical person, an entity authorized by law, or even a people's organization, non-governmental organization, or NGO, or any public interest group. They can file the writ on behalf of persons or communities whose constitutional right to a balanced and healthful ecology is being violated or threatened. So in short, dili kinahanglan ikaw mismo ang directly affected. You can represent a group or community kung ang threat or damage affects the public. and this makes it is very inclusive and powerful, especially for environmental advocacy groups. And next, let's talk about what kind of environmental damage is covered by the writ of Kalikasan. So, for a case to qualify, the damage or threat must be of such magnitude that it involves at least two provinces or two cities. In other words, it's not for small, local cases. It should have a wide or regional impact. So for example, if an oil spills affect the waters of Cebu and Bohol, or a mining activity contaminates rivers across multiple provinces, that's the kind of situation where a writ of kalikasan can apply. Usually, the harm involved goes beyond personal or property rights, meaning it affects the general public or a large community. Ang focus ani nga writ is environmental protection at a national or regional scale, not just private disputes. Third is the distinction from other remedies. So, now to better understand it, let us compare the writ of kalikasan with other similar legal remedies. So first, we have writ of continuing mandamus. This writ is used to compel the performance of a duty under environmental laws, usually directed at government officials or agency who failed to act. For example, if a city government fails to clean or rehabilitate a polluted river despite legal orders, the court can issue a writ of continuing mandamus to make them do it. So, this focuses on forcing action or compliance, often for ongoing or repeated violations. So next is writ of amparo. On the other hand, is mainly protecting constitutional rights to life, liberty, and security. While it can involve environmental issues, its main focus is human safety and security, not environmental protection itself. So kung ang concern is pollution or destruction of nature on a large scale, mas appropriate ang writ of kalikasan, not amparo. And then, we have ordinary civil, criminal, or administrative actions. Ordinary cases can also address environmental problems, but they are usually slower and narrower in scope. Unlike the writ of kalikasan, they don't provide immediate or wide-ranging relief for large-scale damage. Manang the writ of kalikasan is preferred when the situation is urgent and affects a broad area or many people. And next, now that we've talked about the nature and coverage of the writ of kalikasan, let us proceed to another important point, which is who may file this special remedy. So first, we have real parties in interest versus representative standing. So in ordinary court cases, only those who have a direct and personal interest or have suffered an actual injury can file a case. However, the writ of kalikasan is different. It allows a much broader standing, meaning more people and groups are allowed to file it, even if they are not personally injured. And under the rules, the writ can be filed by any natural person, a juridical person, a people's organization, a non-governmental organization, or any public interest group that genuinely works for the protection of the environment. So, dili lang kinahanglan nga ikaw mismo ang directly affected. As long as you have a genuine concern for the environment, you are allowed to file the writ of kalikasan. So, this is what we call representative standing. It's a legal concept that gives standing to those who file the case on behalf of others, especially when the issue affects a large number of people. Now let's talk about filing the writ on behalf of others. So the writ of Kalikasan may be filed on behalf of persons or communities whose right to a balanced and healthful ecology is being violated or threatened. So this is especially important when the environmental damage is so massive that it affects multiple provinces or cities. In other words, when the threat goes beyond local boundaries. So for example, if a company's illegal logging operation destroys forests across two provinces, an environmental NGO or even an ordinary citizen can file the case, not just for themselves, but for the entire affected population. This makes the writ of Kalikasan unique. It promotes public participation in environmental protection. So in short, it empowers ordinary citizens to stand up for nature dili lang maghulat nga ang gobyerno ra ang mulihok. And now let us move on to the next part, which is where and how it should be filed. So this section is about jurisdiction, filing fees, and the proper form of the petition. So the writ of Kalikasan has a special rule when it comes to where it should be filed. It can only be filed directly with either the Supreme Court or the Court of Appeals. These two courts have exclusive and original jurisdiction over petitions for the writ of Kalikasan. So this means that it cannot be filed in the regional trial courts. The reason behind this is that the writ deals with large-scale or nationwide environmental issues. So it needs to be handled by the higher courts to ensure faster and more uniform decisions. In short, this setup centralizes the handling of writ of Kalikasan cases and emphasizes its extraordinary nature as a special remedy. Mao nga if ever na ay major environmental threat involving several provinces, the case goes straight to the Court of Appeals or the Supreme Court, dili na kinahanglan mo agi sa RTC or regional trial courts. Next is filing fees or the absence of cost. So one of the best features of the writ of Kalikasan is that no docket fees are required when filing the petition. So this is consistent with the principle that environmental rights and remedies should be easily accessible to everyone. In other words, bisan ordinary citizen lang pwede gihapon makafile because there is no financial barrier. This helps promote public participation and encourages individuals or organizations to stand up for environmental protection even without big financial resources. Third is form of the petition. So the form and contents of the petition itself or unsa gid dapat sulod sa imong filing. So the petition must be verified, meaning it should include a sworn statement confirming that these facts stated in the petition are true and correct to the best of petitioner's knowledge. It should also contain the following important details, such as the personal circumstances of the petitioner or the group filing the case. Second is the name and the personal circumstances of the respondents, or if their identities are unknown, a statement explaining why they can't be identified yet. And then third is the environmental law, rule or regulation that is allegedly violated or threatened to be violated. Fourth is the specific acts or omissions that cause or may cause environmental damage. Fifth, a description of the extent or magnitude of the environmental damage, specifically that it transcends individual or property rights, and the reliefs prayed for, such as the issuance of a temporary environmental protection order or TEPO, or a permanent injunction to stop the harmful activity. So in addition, the petitioner should attach a documentary evidence or affidavits of witness to support the allegations made in the petition. Basically, everything in the petition should be clear, factual, and properly supported. since this is a serious case that affects the public and the environment. And after knowing where, how, and how to file the writ of kalikasan, let us now talk about the grounds or reasons why the court may issue it. So in short, unsa man gyud ang kinahanglan ipakita aron mag-grant sa court ang writ of kalikasan. First is requirement of magnitude. So the main requirement for the issuance of the writ is the presence of an act or omission that causes or threatens to cause environmental damage of great magnitude. Meaning the damage must be massive in scale, affecting at least two cities or two provinces. So this is what makes the writ of kalikasan special. It's not meant for small or local problems, but for large-scale environmental harm that impacts many people or entire regions. For example, if a mining operation pollutes a river system that runs through several provinces, or if an oil spill contaminates coastal waters across different cities, that's the kind of magnitude the law is referring to. So in essence, the court will look at how widespread and how serious the damage is. So kung dako kayo ang effect, that's when the writ of kalikasan becomes applicable. So next, aside from proving the magnitude of the damage, the petitioner must also show who is responsible and how. So the petitioner has to establish a link between the respondent's conduct and the environmental harm. That conduct may be through direct action, negligence, or even failure to act when they had a duty to do so. So for instance, if a government agency ignores illegal logging activities or a company discharges toxic waste into the sea, both can be held accountable under the writ of kalikasan. So the idea is to prove that the respondent's action or omission led or could lead to serious and irreversible harm to the environment, thereby endangering life, health, or property of people living in the affected areas. So in short, dapat makita nga ang ilang buhaton or pagkawalay buhaton has a direct impact on the environment. And lastly, the court will also consider whether there are other remedies available that can already address the situation. Although the writ of kalikasan is not strictly a last resort, it is considered an extraordinary remedy used mainly when the scope and urgency of the threat demand quick court action. So if the problem can already be solved through another more specific environmental remedy, like a writ of continuing mandamus, which compels government agencies to perform their environmental duties, so the court may decide to use that instead. However, the primary test always goes back to magnitude. If the environmental damage is truly large scale and endangers the lives and welfare of many, the writ of kalikasan remains the most appropriate legal tool. And for the next part, Ms. Marian Tomika will discuss it.
Hello everyone, I am Marian Tumika and I will be continuing our report. So first, let's talk about the procedure after filing the writ of kalikasan. So, once a petition is filed, the court checks if it is complete and correct in form and substance. Kung sakto ang petition, the court may immediately issue the writ of kalikasan or conduct a short evaluation. And after issuing the writ, the respondents, usually mga companies or government offices, are required to submit a return within 10 days. The return must include their defenses or explanations, the affidavits and evidence and proof that they followed any temporary environmental protection order or TPO. And after the petition and the return are submitted, the next step involves hearings and possible temporary orders. The court may hold summary hearings to speed up the process. Dili kinahanglan nga very strict and technical rules of evidence. kaya ang goal is fast and fair decision. The judge can also go to the site for ocular inspection or ask for help from experts. If there is a danger or immediate damage, the court can issue a TIPO or the temporary environmental protection order, like temporary stop order that lasts for about 72 hours. For example, if a company is dumping toxic waste in a river, the court can issue a TIPO to stop them immediately while the case is ongoing. Aside from hearings, there are also special court measures to make sure the case is fair and that the petitioners are protected. The court can order discovery measures like producing documents or inspecting areas. If the respondents file cases just to harass or intimidate the petitioners, the court can dismiss them under the SLAPP defense or the strategic lawsuit against public participation. For example, when a big company sues environmental advocates just to silence them, the court can stop the using the SLAPP rule. Next, we have the possible reliefs granted. So if the court finds the petition is valid, it can issue several types of reliefs or remedies to protect the environment. So first we have the cease and desist on desist order. So kani siya is kanang to stop harmful activities. For example, a mining company may be ordered to stop operations. And next, we have the restoration and rehabilitation. So kani siya is the respondent must fix or clean the damaged area. For example, kanang mga reforestation or river cleanup. And other equitable remedies kay the court may order continuing supervision or continuing mandamus to make sure orders are followed. And next, we have the contempt and sanctions. So if someone disobeys the court, they may face fines or penalties. So next, we have the significance of a significant jurisprudence. So let's look at some important Supreme Court cases and decisions involving the writ of Kalikasan. Through the years, Supreme Court has handled many writ of Kalikasan cases, especially about mining, pollution, and reclamation projects. The court always reminds us that when in doubt, choose to protect the environment. This shows that environmental protection is always the priority. However, even if the court is liberal in accepting cases, it still requires strong and clear evidence of large-scale harm. Next, we have the strategic importance and limitation. So let's discuss why the writ of Kalikasan is important and what limitation it has. So the writ of Kalikasan is a strategic tool for communities, NGOs, and advocates. It allows them to fight for the environment without high legal costs or complicated procedures. For example, fisherfolk and residents once use it to stop reclamation projects that threaten the coral reefs and marine life. However, there are limitations. It only applies to widespread or national harm, not small local issues, and success depends on strong evidence showing real danger, and it also needs coordination with government agencies like DENR and LGUs for enforcement. So before we end, let us have a quick summary of everything we've discussed. So ang legal source niya is AM number 09-6-8-SC Rule 7. Ang purpose is to stop or prevent large-scale environmental damage and who may file kay any person, organization, or NGO, where to file kay Supreme Court or Court of Appeals, and a requirement is harm must affect at least two or more cities or provinces, and no filing fees, free to file in the name of public interest. And ang procedure flow niya is file petition, court may issue writ, respondent files return, summary hearing, possible depot, and final judgment. Reliefs include cease and desist orders, rehabilitation, and continuing court monitoring. So this writ ensures that environmental justice is accessible to all, especially to communities affected by large-scale destruction. So the writ of Kalikasan is not just a only legal wait, the writ of Kalikasan is not just a legal remedy. It's a shield of our environment and our people. It empowers us to stand against environmental abuse and reminds everyone that protecting nature is everyone's duty. If we take care of nature, we will nature will also take care of us. Thank you, and let's continue working together for a greener and better future.
That's all for today, sir and classmates. So once again, I am Clarissa May Opipito, and
Marian Tumika.
thank you and goodbye.